Okay, good morning, good afternoon for everyone who is here. I am here with two of my colleagues who will introduce themselves. And we're going to be presenting for you on COVID-related issues and a lot of interaction between us. My name is Leslie Wallace. I am an employment attorney at Ogletree Deakins, as you can tell from our background, and I do mostly advice and counsel work and am one of the lead attorneys on COVID-related questions for Ogletree and have been during the pandemic. I'm going to toss the baton to Danielle to introduce herself and then to Nicole.
Good morning, afternoon. Danielle Goodman here. I'm an of counsel in the LA office. I work a lot with Leslie and with Nicole. My focus of practice is mainly litigation. I do some advice and counsel work, but I'm involved in a ton of litigation. So I see these issues that we're going to talk about today pop up in litigation that is really getting hot and heavy.
Hi, everyone. I'm Nicole McAtee. I'm a shareholder in the Los Angeles office as well. I predominantly do single plaintiff defense, harassment, discrimination, and then also quite a bit of advice and counsel. I was on the COVID response team that Ogletree had with Leslie, and we have been tracking these issues since COVID-19 became a thing.
During the course of the program this morning, you can type into the question and answer, or you can use the chat. I think for questions, it's best maybe if you use the question and answer format, but it doesn't really matter. Either one of them will work. We will try to monitor them both and look for, if we can get to a question right away, we will try to respond to it depending on the number, or otherwise we will try to leave a little bit of time at the end. So, Danielle, we're going to start with you, and we're going to start with a potpourri question. Let's take potpourri for 20 and see what that question is. There we go.
Okay, so the question asks, in the hierarchy of all California COVID-19 regulations, health orders, county and city ordinances, and executive orders, which of these has controlling authority? The general rule of thumb, if we can, I'll answer the question. There we go. Okay. So the general rule of thumb is that the public should consider the most restrictive to be the answer that controls. So the one that's the most protective of public health and the one that is, more strict, that should be the one that controls, or at least interpreted that way.
And actually, before we continue on here, because of the rules and the most restrictive ones, some of you may be aware that the Cal OSHA's board met to make some modifications to some of the regulations that we need to follow here in California, and set forth a number of rules that raised a lot of questions, probably more questions than answers. But they were put out there. Then the board met again, where we were anticipating that they might have some additional changes, but weren't sure precisely where they were going to go. So we actually revised slides. They actually abandoned all of the changes that they had proposed on June 3rd, and they're going to put forward a new proposal and vote again. So there may be some slides in here where we're going to have to modify them as we go, because the rules changed between yesterday and today. We'll note those for you, though, as we go. Okay, Danielle. Let's go with returning. So we know what rules we need to follow, the most restrictive ones. What happens when we're returning to work? Let's do leaves of absence for 30.
Okay. The company is reopening the office. Oh my God. No more black sweatpants. Erica tells her company that her anxiety about getting COVID-19 precludes her from returning to work, and also tells the company that she will get a note from Dr. Martin if they make her go back to work. What should the company do? So the company should make sure that they follow a process. And the first thing to do is to establish the COVID process. Now, it's important to establish a COVID process because you want to give consistent answers. You want to have a point of contact. You want to make sure that you're giving your employees consistent information, and also making sure that you're asking consistent questions and abiding by the various regulations in terms of what you can and cannot ask. So establish a point person so that you have a centralized system. And then once you have that point person or that system in place, treat this like any other accommodation issue. Does Erica have a disability? Is her anxiety something that her doctor can provide a note for? If so, do the reasonable accommodation process, interactive process, just like you would with anything else. So once you get the information from Dr. Martin, who writes a note that says, Erica has anxiety, she can't return to work, she has to work from home, you want to get additional information from Erica. What are your concerns? Maybe we can address them and accommodate you so that you can actually work in the workplace without any issue. Maybe you're doing things in your workplace that shows that you're trying to make it as safe as possible. And once Erica is educated about those things, she will feel great about coming back into the office. Another thing you should think about is maybe she is unable to perform her duties working outside of the office, so that, she's unable to perform the essential functions of her job. So accommodating her by allowing her not to be in the office would cause an undue hardship to the employer. Is there a direct threat? Direct threat meaning there's something that would be at the work that poses a significant risk of substantial harm to the employee's own health condition. And that is an individualized assessment that is a pretty high bar. If there's nothing that can be done to allow the employee to work in the office because, of anxiety, for example, consider a leave of absence, allowing that employee to take a leave of absence if they can't perform their work from home. So I think that covers it.
Yeah, I think that does it. Let's do the next question about returning to work then, and how you would accommodate this one.
Okay. Company is reopening the office. All right. So Brooke asked to work from home so she can take care of her Aunt Phoebe, while Tad says he can't return because his daughter Dixie's school is still closed. What does the company do? Again, start off with the process. Who is going to be the person that's the point of contact for these COVID-19 return to work questions? And tell the employees, if you have any questions or issues, please go to XYZ person. Then once that employee has gone to your designated COVID-19 return to work person, figure out, do these issues that the employee is bringing to you raise any issues under FEMLA or CFRA? And for those of you in the audience who aren't steeped in employment law like Leslie and Nicole and I, FEMLA is the federal leave act that allows people protections to take leave of absence, and CFRA is the California equivalent. So in order to qualify for FEMLA and CFRA, you have to meet certain conditions. Now, under FEMLA or CFRA, you can qualify to take a medical or take a leave of absence to care for a family member, but that's generally defined as a spouse, parent, or child. So Aunt Phoebe may not apply. There may be an exception where she applies, but generally probably doesn't apply. And so what you would want to do with Brooke is try to see if there's anything that you can do to accommodate her, so that she can continue working. Maybe she doesn't need to return to the office. Maybe she can change her schedule so that she can still take care of her aunt. Try to be flexible with her because she's been doing this from home for months, taking care of Aunt Phoebe and doing her work. So there should be some workaround. Try your best to do that. Tad is a little bit different. He has his daughter who is in school, and he can't go back because she can't go back. Again, this wouldn't qualify under CFRA, even though it's his daughter, because she doesn't have a serious health issue that requires him to take care of her. She has a school issue. He may qualify for leave under EFMLA, which is the emergency FMLA statute, that allows people to take leave when their kids' schools are not open. This is in effect until September 30th. but let's say it's not in effect anymore, then also consider what you've been doing this whole time. Has Tad been able to work on a different schedule? Is he able to do his work from home? And so you want to try to see if you can accommodate these people. And finally, review your local ordinances to make sure that there isn't anything that's on point and telling you what to do. Local ordinances meaning like LA County reopening guidelines, LA City reopening guidelines, wherever you are.
I did want to step in and comment also on that EFMLA. That's a voluntary process right now under the American Rescue Plan Act. Employers can actually offer the time off, time off and get compensated for it, but you need to figure out whether or not you even fall into that category. I'm not sure if there was anything else that I wanted to add, but just going to put that out there that there's a lot of integrated interacting ordinances and rules and regulations, federal and state and local, and you need to review them all in determining whether or not these folks have a right or you just want to do the right thing. So, and remembering that this is going to be a transition for many people, and that flipping a light switch and telling everybody to come back in when they don't have the structure to do that, or they have a lot of anxiety around it, may not be the best way to get your workers back to work in a way that is actually efficient and effective. All right, Danielle, one more return to work question before we head into a different area.
All right, so in addition to unpaid leave, what types of COVID-19 accommodations should an employer consider? Even though this probably was a more difficult question in the beginning of COVID, I think we've all kind of seen just in our daily lives some of the accommodations that employers can offer. If you go to a grocery store, you can see one-way aisles. So that'll allow the flow of people to be in a certain direction, minimizing, people coming together in a way that's not socially distant. Plexiglass to create barriers between people, barriers like tables that create the social distancing. Modified work schedules that allow people to be working at different times. A temporary transfer so that some people are working in some office spaces versus others, again, increases social distancing, and then additional time for remote work to allow people to work from home.
Okay, well, we are going to spend a few minutes on Cal OSHA's new requirements and now new old requirements because we thought we were going to have a whole lot of new ones to provide you with, and we don't. So let me start with, so Cal OSHA issued a set of what were called emergency temporary standards that went into effect on November 30th of 2020. There's they're found there's a model COVID-19 prevention program that goes with that, and the Cal OSHA standards, it's under Title 8, Division 1, Chapter 4 of the standards. So as I said, June 3rd there was a vote. We thought everything was being amended, and that in about on June 15th, they were going to take effect. But some of those changes were inconsistent with what the CDC is now recommending and what the California Department of Public Health were recommending. And so there was another hearing where people put forward some of the problems and issues they'd seen, and we'll touch on a few of that. And for example, there was a whole section on N95 masks that was looking like it was going to be incredibly difficult to implement. And I guess late last night, the board said, you know what, scrap that plan that we were going to put into place on June 15th. We're going back to the drawing board. We're going to meet again on the 17th. And those, whatever they vote on the 17th, assuming they do vote on something, typically goes into effect 10 days after that. So by the end of June, we may see changes. So the other thing that was in this new set of rules was around vaccinations, because when this was adopted initially, the ETS was adopted initially, there wasn't any vaccine on the market yet. there wasn't any instruction or direction around that. So we're back to that place, even though people are coming back, some vaccinated, some not. So but we had a California COVID-19 prevention plan in place. There were additional elements and we were going to have to change them. We're back to the initial COVID-19 prevention plan, which now, as it says, amended June 4th, was not. It is under further review now. It has 11 elements in it, and those elements include a system for communicating things like reporting COVID symptoms, close contacts, workplace hazards that people see. So they're actually asking people to come forward and say, what do you see that can be improved? How medical conditions put people at risk, information about testing. All of those things are still in place, and a communication of your policies and procedures. So that has to be part of your plan, is actual communication. Then identifying hazards, investigating and responding to COVID-19 cases. There is another law that went into effect January 1 about giving notice to people who have been exposed, was the language that was used initially. We're back to that language. Probably will change to close contacts in the future. The original ETS, again, in effect right now, says you have to offer testing if someone is exposed to COVID-19. That language may change as well. How to correct hazards. There is training that needs to be provided for everyone. That is in place right now. We expect that with the revisions, there will be additional training that needs to be done, but it doesn't mean you'll have to start from ground zero. So if you're bringing people back June 15th, start training them now. And if additional elements are added, you'll just have to provide the additional elements. You have to train about face coverings. There was a definition of face coverings, which we'll talk about a bit later. That is now changed back to the original, something covering the face, that it doesn't have any holes in it. Physical distancing, other engineering controls, things like maximizing outside air, things like that. Record keeping, reporting, and access to the report itself, which your employees, if they want to see your prevention plan, must be allowed to see it. Excluding close contacts or excluding exposed people and COVID cases. This is the part of the plan or the part of the plan that gets the most attention, because it has to do with people getting paid for being excluded from work. So that's the thing that hits the employers the hardest. You have to maintain wages and benefits, seniority, and all other rights and benefits, and pay at the regular rate of pay if someone's excluded because they were exposed at work. The pay does not apply if the exposure was not work-related, but you do need to provide benefit information as what benefits do I have if I have to stay home? And finally, there's some return to work aspects around symptoms that have, again, not changed. If you have an illness, injury, illness, and prevention plan, that is not the same as this. This is in addition to it. If you or any of your clients have 10 or more employees, they should already have an IIPP. If they don't, good time to update them on that. Right. Let's go on to those testing rules. So true or false, and if you want to type into our chat, that would be great, but you need not. As a California employer providing COVID-19 testing, if you are providing it for your employees, must you provide a PCR nasal swab FDA approved test? True or false, you have to do that. We'll give folks a moment to see if anyone, we've got a false so far there. See if anybody else is going to pipe in. If not, okay, your answer was correct. That is false. These are the three elements that you need to have. A test that detects the virus, that is approved by the FDA, and that is not an antibody test. Those are the only restrictions on what kind of testing can be done. All right, well, what about that training that I talked about? So what are those topics that you have to provide? And for those of you who are going, oh, I had no idea we had to do training, guess what? You do. Now, it doesn't need to be a 2-hour training like our anti-harassment training, but it probably is going to take you, I don't know, 20 to 30 minutes max. There's no real set of exactly how you have to present it, but the topics are listed. So you have to include, again, this was going to change and for some additional items that were going to be included, but right now, your policies and procedures that are in place to protect employees, how to identify and evaluate hazards, information about benefits, absolutely key. So you can't hide what benefits are available to your employees, either if they're excluded or if they become ill or they need to be vaccinated or any of those things. You need to give them that information. You need to provide information about the disease and its spread. How is it spread? About physical distancing, how the virus travels, about face coverings, the importance of hand washing and the use of hand sanitizer. And mind you, this has not gone away. Yes, we are opening up. We still need to be washing our hands. We still need to be sanitizing. I do notice in a lot of workplaces, or when I go to the grocery store now, there used to be, hand sanitizer everywhere. It's disappearing. Don't think it's a great idea. If your workspace has it, keep it. It's going to be evidence that you're actually doing the right thing vis-a-vis your employees and for yourself as well. Let's keep safe. And then what are the symptoms if people still don't know them? They were going to add in some information about policies, accessing, testing, and vaccination. I expect they will ultimately. There will be some training around vaccination, but not needed at the moment. All right. And now for one more in this area, we're going to go to potpourri for 50. So, oh, I'm sorry. I'm going to go back. That's actually Danielle's question. So, how is a face covering defined under these new rules? And when must a face covering be worn at work? Well, this question had an interesting set of answers, which may get adopted, but this is not the information that we're going to be currently using. So, as I said, a face covering is something that you wear over your face and mouth, and it can include things that you pull up over your face, like a scarf or a turtleneck or a collar. It could have been a single layer. The new definition, and this was part of the problem, talked about respirators, which are N95, not KN95, but N95 masks, a medical procedure mask, or that things had to be double layered. And so I expect they will change the definition of face covering somewhat, but perhaps in a different way. And there also were some new rules around wearing them with vaccinated people versus unvaccinated people. Again, my expectation is there are going to be some different rules, but right now, because the ETS goes back to November 30th, there are not. There's no reference to vaccination in these existing rules. All right, I'm going to kick this over to Nicole to do, this potpourri question that I said it was Danielle's, but it's not. It's Nicole's.
Okay, folks, so the question is, Jackson wants to comply with California requirements regarding testing unvaccinated symptomatic employees. Can Jackson ask employees to perform a take-home COVID-19 test and call with the results? Can Jackson ask employees to report symptoms if they are vaccinated? So first, the question, we were assuming that the ETS was mandating vaccinations or verifying vaccination status. That has since changed. We don't have that anymore. So we're just going to assume that Jackson decided he wanted to look into these on his own. So the answer to the first question is that Jackson can ask employees to perform a take-home COVID-19 test. However, he probably shouldn't mandate it. And the answer to the second question is, and can Jackson ask an employee who reports symptoms if they are vaccinated? Yes, he can. He can ask if the employee is vaccinated. It's not the same. California doesn't treat this particular inquiry the same as it does asking an employee for a medical diagnosis or a medical condition, which under California law, employers cannot ask employees. But if the employer is collecting or maintaining vaccination status, it has to be treated the same as confidential medical information. So what that means in a practical sense is that it should be kept apart from the personnel file in a separate medical file usually. And it should have the same sort of protections that the employer uses for like ADA, FEHA information. So think leave of absences, doctor's notes, etc. And if a couple of things to be mindful of for employers, since Jackson is asking employees to do the take-home test, if he has non-exempt employees, hourly employees, he actually has to pay them for that time that they're taking the test. And he also needs to pay them for the cost of the test if he's requiring them to use a take-home test. He could send them to a free testing site if they choose. They are available. Now, circling back to what the ETS has not really answered for us yet because they decided to change it up on us last minute, Jackson and the company should develop a policy that addresses when an employee who is vaccinated but tests positive or is symptomatic and how you handle those situations. So currently, under the information that we have and the science that we have, vaccinated individuals, viral load may be too low to infect others. So even though, but it's not absolutely clear, and the ETS does not provide an exemption for fully vaccinated individuals who have symptoms or are test positive. So what does that mean in layman's terms? If an employee tests positive for COVID-19 and they are vaccinated, the employer still has to exclude them from the workplace. There's not some sort of exemption, which we anticipate that a lot of employees are going to have some pushback on that. Another thing to be mindful of is when you are discussing vaccination status, whoever is asking those questions, they should know that they can't really go beyond the vaccination status. So for example, if an employee says, I'm not vaccinated, the employer or whoever's asking the question should not say, well, why would you not be vaccinated? Do you have a medical condition? Is this a personal choice, et cetera? No follow-up questions on that end, because you really can get into that ADA, FEHA realm. And again, employers are prohibited from asking for medical diagnosis, sort of medical conditions. Another thing to be mindful of is we actually have one county in California, Santa Clara County, that requires employers to obtain vaccine status. And if a person responds that they were either not vaccinated or they refuse to respond, the employer must again ask every 14 days to see whether the employee's status has changed. So if an employee refuses to respond to the question, this particular county is actually mandating that the employer treat them as unvaccinated. While we're seeing a lot of different states across the US that are forbidding employers from asking about vaccination status, this seems to be a sign that California might be heading in an opposite direction because one of the counties is actually mandating the question. We will see how other counties react. For example, Los Angeles, we're tracking it closely. We're not sure how they're going to handle that.
All right, Nicole, is there anything about if somebody does end up being a positive case or exposed, what you need to do in terms of notices? And I think maybe under potpourri 10, we'll find another true false.
Okay. So the question is a true or false. Notices about close contact exposure should include the name of the COVID-19 positive person who came to work so that employees can figure out whether they should be tested or not. Anyone have any guesses as to the response to this?
We gotta know. We gotta false.
So, all right, we're gonna go through and go through some of the responses. So The answer is false. I know a lot of you might think, or maybe you don't, but a lot of times employees or employers, I have had this question. I do a bit of advice and counsel, and it's one of the predominant things that I hear is like, well, how can we really do contact tracing if the employee, we don't disclose to the other employees who was the positive case? So the state of California wants you to figure it out and do it as best as you possibly can without releasing the employee name. So AB 685 requires that an employer provide written notice when a qualifying individual may be exposed in the workplace. Must be done within 1 business day of employer receiving notice of a potential exposure. You must notify all employees on site at the same work site during the infectious period, and you cannot reveal the name. So also be mindful that while you cannot reveal the name on this particular form, there are forms that you have to identify the name. So Cal OSHA Form 30, you do put the employee's name. Now, some of you might ask, like, what form are you possibly talking about? So Cal OSHA 30 it's a log of work-related injuries and illnesses. Employers have to record information about every work-related death and about every work-related injury or illness that involves loss of consciousness, restricted work activity or job transfer, days away from work, or medical treatment beyond first aid. You also have to record significant work-related injuries and illnesses that are diagnosed by a physician or licensed healthcare physician.
All right. Here we go. So let's get through the leaves and accommodations. Maybe you can bring us home, on Nicole, on those. So what about leaves and accommodations for 10? Here's an example that might arise.
Okay. So the question is, in 2020, Luke took 60 hours of LA County paid sick leave to care for his mom, who tested positive for COVID. Now in 2021, Luke tests positive for COVID-19 right after caring for his grandmother, who also has COVID-19. Luke seems like a really great guy, really taking care of the whole family here. For how much paid sick leave is Luke eligible?
Okay, so we've got some choices.
Our options are 20 hours of California supplemental paid sick leave, because his employer can count the 60 hours of LA County leave against the 80 California hours. 80 hours under the Cal OSHA emergency temporary standards, 80 LA County leave hours because LA reauthorized its COVID-19 leave in January 2021, or 80 hours of California supplemental paid sick leave because new legislation effective 4/29/21 created a new bucket of leave retroactive to 1/1/21. Okay, for the first one, you may want to select this because you think the employer gets some sort of credit. That's not actually the case. The California supplemental paid sick leave became available again on 4/29/21 and is retroactive to 1/1/21. It created a new bucket of paid time off. So you may be asking, what if an employee took unpaid time off between January and March 2021? If an employee took time off, they may be entitled to retroactive payment. So if they took unpaid time off, the employer might still have to go back, reissue some wages for that time period. If an employee used their vacation during that time period, the employer may have to also reload their vacation. It's up to the employee, though, what option they want to choose. So make sure you confer with the employee before doing anything. So for option B, this is not the correct answer because he caught it from his grandma, and ETS-BA benefits only apply to workplace exposures. We're assuming the exposure with grandma did not happen in the workplace. For option C, no, because LA County actually reauthorized the leave. They did not add more leave, and he has already used it. So for those of you guessed number D, ding, 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 correct answer. If the new California supplemental paid sick leave, as I said, created a completely new bucket. So this would be the correct answer. If the leave already given, for example, under FFCRA voluntarily, the FFCR leave runs concurrently with California supplemental paid sick leave, and the company actually gets a tax credit. This is for companies under 500. So make sure you're talking to your tax advisors on that, and or employment lawyers for whether you qualify. If the company has a policy giving paid leave, that might also run concurrently as the local ordinances, so make sure you're double checking on that.
All right, Nicole, let's bring us home with the last of the leave and accommodation questions.
All right, our question is, February 2021, the Orange County Online Gazette excludes Laura from work for 10 days because she had close contact with Luke, who was positive at work. Does she get paid for those 10 days? And if so, how? Option 1, 80 hours of Cal OSHA ETS minus the Orange County COVID paid sick leave she already used, 70 hours of ETS plus her 10 hours of remaining PTO or vacation, 40 hours of ETS plus 40 hours of California paid sick leave. She hasn't used any yet this year. Or D, none of the above, she can work from home. Okay, remember to go back to the basics. First, take into consideration that there actually is no Orange County COVID paid sick leave. Us folks in Los Angeles are extra special because we get a separate ordinance that protects us with that, but Orange County folks don't get that same protection. So A would not be correct. It is a trick question. Mm-hmm. Option B, this is also incorrect because you can't force the use of PTO or vacation for ETS. Remember that the employee cannot be forced to do that. Option C, if exposed at work, she would be entitled to ETS if she can't work. And the employer can require use of California supplemental paid sick leaves for the whole 80 hours. This is the only time that California supplemental paid sick leave can be required. However, D is the correct answer. There's no evidence that she can't work from home. If she can't work from home, she could have the supplemental paid sick leave, she could use it. If the employer is excluding an employee from the workplace and they can't work from home, only time you can make them use the California paid sick leave. So you might think of an example of an employee that doesn't really have a setup to work from home. You know, maybe while it's rare, they don't have internet, they don't have phones, you know, some of that other stuff, or they simply can't do their job remotely. If the employee does have available coverage through any of these, can't work from home, can't report to work due to the exposure at work, then the employee does have to pay the employee's regular wages. If the employee was disabled, then they might also qualify for state benefits as well, disabled due to the COVID-19 diagnosis.
All right. I think we're going to kick it over to to Danielle, who's going to talk to us about all those vaccine questions that you've got, some of which have changed since yesterday, and some of which will be just fine. So here's your first one.
Can an employer require that an employee be COVID vaccinated? This is a question that I get all the time from friends and family, and everyone has an opinion. The answer is that although there is no definitive answer from the EEOC, the EEOC says that employers may mandate vaccinations, which means that, yes, an employer could require that employees get vaccinated. I saw a question in the Q&A, can an employer request to see an employee's vaccination card to prove vaccination status and make a copy of that card if they keep/treat the info the same as confidential medical information? Yes, the employer can ask to see proof of a vaccination, and yes, they put it in the, or they treat it as confidential medical information, so it's not technically part of the personnel file. So employers can mandate that employees get vaccinated, but employers should keep in mind that can get sticky in some circumstances. For example, what do you do about employees who can't get vaccinated because of a disability or a sincerely held religious belief? You have to try to accommodate those folks. And those accommodations can be anything from a leave of absence until the pandemic ends at some point in time, or requiring those unvaccinated employees to wear a face mask at all times, socially distanced, et cetera, et cetera. So employers should just be careful before mandating, but yes, they can mandate. It can be a requirement.
I think Nicole mentioned the Cal OSHA 300 log, and another issue around mandating vaccines is you need to actually then keep records of any reactions, negative reactions to the vaccines. If you mandate them, you got to put it on your log, and those logs need to be kept for 30 years. So that might be another reason that you want to consider whether or not you want to mandate it. Finally, I want to say that I've had the experience where I have had a client who did not in the past mandate vaccines, a healthcare client, and then decided last year to mandate flu vaccines, thinking that they would get greater cooperation. Instead, what they found was that people who had taken the vaccine, the flu vaccine in the past, decided that they didn't like their employer telling them what to do, and suddenly had a disability that prohibited them from being vaccinated, or a newfound religion that or belief that meant that they couldn't. And the employer was spending a lot of time both going through the interactive process and then not actually ending up with a greater degree of cooperation than had they just either incentivized it or made it voluntary. So just to know, what's your goal, and is mandating it going to get you there? And what are the administrative headaches for you if you do? All right, let's continue on the vaccine train.
Okay. Should an employer pay for or provide vaccines? The answer is that the employer can do that, but you get into sticky situations because it creates an employer-sponsored health plan. So you should contact a benefits attorney to help you with ERISA compliance in that regard, and incorporating the payment of the vaccination into your health plans. Our recommendation, or the best advice that we can give, is that it may be easier just administratively to provide your employees with places where they can get vaccinated, and to let them know if they have any questions, they can contact your the COVID-19 liaison or response person.
And we've got a question in the Q&A right now that's related to vaccines, so I'm going to throw it to Leslie.
I think this one was answered.
Yeah.
Okay, good. Perfect.
We've got it. We got it covered. All right, let's go to, what about discrimination in vaccines?
Okay. Is there a risk of discrimination claims for unvaccinated employees? Can work assignments be made based on whether an employee was vaccinated? Yes, there is a risk of employees being discriminated against. You should consider moving unvaccinated people to positions where there's minimal customer contact. But be careful that if you do that you're not minimizing their potential for advancement in the company. For unvaccinated folks, you may accommodate around that by giving them more PPE to ensure that you have a safe workspace for everyone. So just make sure that if you have people that can't be vaccinated because of religious beliefs or their own disability, that you're not treating them differently in terms of advancement in their career, pay, et cetera, et cetera.
All right, let's look at this return to work and vaccine question. Potpourri for 30. Let's see if we can get an answer that actually is going to work here so that we can give Danielle her 30 points.
Okay. Rosa has come back from a temporary assignment in Europe on June 1, 2021. She would like to return to working in the downtown Los Angeles office. Who knows why, because that commute probably sucks, but that's what you want to hear. She received the Sputnik V vaccine in Russia. Can we consider her vaccinated? This is a really exciting moment because as of last night, the answer is we don't know. Like Leslie has been saying, the Cal OSHA board voted last night, and the rules basically reverted to, or the emergency order basically reverted to November 30th, which was before there was a vaccine. So before last night, the answer to this would have been no, we don't consider her to be vaccinated. But now we don't know. So hopefully we'll get more guidance on this when OSHA votes on June 17th.
Danielle, can you think of some places where this this idea of only an FDA approved vaccine or emergency use vaccine might be a problem for like national employers.
Yeah, so when people have people work, so people who work in Europe and agricultural workers, if they receive the AstraZeneca vaccine, for example, they're still going to have to wear masks under the new order that comes through on June 15th, reopening California, and they're not going to be entitled to some of the benefits that the fully vaccinated folks are going to be entitled to, which could be difficult for them in terms of, for example, an agriculture worker having a mask on in very hot temperatures. That could be a risk to their health and safety. So that's where OSHA comes in. So we have to keep a lookout on this and try to figure out how to best work with people who are genuinely trying to get vaccinated and stay safe.
Right, so let's go back to finishing up the vaccination section with incentive programs. So trying to get folks vaccinated, and here in the US, we do have approved or at least emergency use authorization approval.
Right. Okay, can an employer set up a COVID vaccination incentive program? Yes, absolutely, the employer can do that, but the employer should be careful about doing it. So if the incentive to get a vaccination is related to a vaccination that the employer is providing, either paying for or, having a vendor come to the work site and give people vaccinations, HIPAA rules may apply. If the employer, if an employee is unable to get the vaccination because of their own disability or religious belief, the employer should provide an alternative for them to get the incentive too. And you may ask the question I initially asked, which is, what's the incentive, or what do you do if the incentive to get a shot is, some sort of gift or whatever, if you can't get the shot? And one of the things people do is they offer additional training to people who cannot be vaccinated. And if the people who cannot be vaccinated take that training, they can get the incentive. So the incentive is also something that, if the incentive is connected to your healthcare plan, then HIPAA regulations apply. So it's employers may want to be careful about how they set up the incentive program related to whether or not they provide the vaccine itself.
Yeah, and I wanted to just pop in here also because the EEOC has sort of opined that if there's too great an incentive, it could be problematic, which seems crazy when the state is giving away millions of dollars for you to get vaccinated. But as Danielle and I have discussed, your relationship with your employer is a bit different than your relationship with the state. So noting that you shouldn't probably go crazy, although we have shelved, the Department of Labor shelved the idea that it could only be a de minimis standard, generally speaking. So just a water bottle or something. It can be something more than that, we think, but probably not thousands and thousands of dollars. You could walk into a discrimination or problem there, or sort of incentivize people maybe who have a health condition who shouldn't get one to get it just because they want to get the money. All right, and finally.
Leslie already started talking about this. What types of incentives can be provided to the employees to encourage them to get the vaccine? So lots of employers do extra PTO, which is, pay time off, either for obtaining the vaccination, either for use for obtaining the vaccination. So if you, want to take a day off after you get it, or as a reward for receiving it. Some employers do raffles. Some employers are offering food, maybe a lunch, gift cards, it just depends. Again, like Leslie said, make sure that it's not such a great incentive, and by great, I mean high value, that it may encourage people to get it who shouldn't be getting it for health reasons.
And the city and the county of LA, I believe it's both of them at this point. Again, check the local ordinances when you're going to do anything. actually have paid time off to get the vaccine now. It's I think 4 hours each time. But that's not a statewide ordinance. All right. So now Nicole, we're gonna have to zip through the workers' comp issues because we'd like to leave a couple of minutes at the end, but let's start with initiating claims for workers' comp.
Okay, the question is, should we offer to initiate a workers' compensation claim for any worker who tests positive for COVID-19? Go to the answer on this one. So the answer is going to be, first off, the key question is, does the employee consent to it? But there are risks with initiating a claim. You're disclosing the information about an employee who tests positive. So you want to make sure whether the employee agrees to that or not. So don't initiate a claim unless the employee has said yes. The employee may not become ill or need workers' comp. So you've just now opened another claim when it may not be necessary. Employee could be eligible for ETS pay during period if not ill but positive. Employee may be required under ETS and labor code to use paid sick leave, but only as permitted by law.
And how about doing reporting to the administrator?
Okay, do employers have to report employees with COVID-19 to their workers' comp administrator? If so, when? The new labor code section requires employers to report employees who have tested positive. You report to the workers' comp administrator within 3 business days of when employer knows or reasonably should have known of a positive test. Employer may not provide personally identifiable information unless the employee asserts the infection is work-related or has already filed a workers' comp claim. The information should include the date the employee tests positive. It's the date the specimen was collected for testing, specific address or addresses of the employee's specific place of employment. I'm not going to go through all of them just because we are on a bit of a time crunch, but you can certainly look them up or ask your favorite employment lawyer.
All right, so how do we really know this?
How do we really know if COVID-19 is a work-related or a true workers' comp claim? So you're going to do what you would normally do. You're going to do a good faith investigation. You gather facts and information, consider workplace and community exposures. You confer with your workers' comp carrier to see whether it should be covered. Ask yourself whether there are any cases in the workplace. If you have a couple of cases in the workplace, it's probably that's where the employee got it. So just use a little bit of common sense on this one.
All right. Well, we're jumping through these, which is just great. So this one is a little bit more complex, so you can take your time on it. And what happens when is an employee injured?
Okay, so when is an employee considered injured by COVID-19 for workers' comp purposes? Well, if the employee is ill or dies from COVID-19 and the employee tests positive or is diagnosed with COVID-19 within 14 days after the employee performs services at the employee's place of employment, at the employer's direction. So a couple of caveats there. I don't imagine that you're going to have employees showing up at your work site doing work that is not at your direction, but they've added that sort of caveat. The date of injury is last day employee worked at the employee's place of employment. The positive test occurred during a period of an outbreak. So some different scenarios where the employee is considered injured by COVID-19 for workers' comp purposes. And an injury is described as including illness or death resulting from COVID-19 where the employee has tested positive for or pre-July 2020 was diagnosed with COVID-19 within 14 days after a day that the employee performed labor services at the employee's place of employment.
All right, so then we talked about an outbreak for workers' comp. So what is that?
Okay, so remember workers' compensation actually has their own standard for what an outbreak is, so keep mindful of that. An outbreak exists if within 14 calendar days, one of the following occurs. For an employer with 100 or fewer employees at specific place of employment, 4 employees test positive. For employer with more than 100 employees, it's 4% of the number who reported to a specific place of employment test positive, or specific place of employment is ordered to close by the health department, OSHA, school superintendent due to COVID-19 risk. If there's an outbreak, sorry, say if there's an outbreak, then the injury is presumed to rise out of and in the course of employment.
Right. Okay, so there are also outbreaks under both the ETS and under the California Department of Public Health's rules. And those are unfortunately different numbers than those that Nicole was just discussing. So an outbreak under the ETS or for the California Department of Public Health, and again, check your locale wherever you are or your clients are to determine whether or not they have different rules in that area, because again, the most restrictive is what's going to apply. For purposes of the emergency temporary standards, an outbreak is 3 or more. Remember, the level for the workers' comp was 4 or more with 100 employees or less, and 4% if it was more. This is a 3 or more within a 14-day period. And a major outbreak is 20 or more cases within a 30-day period. I'm hoping we're not seeing a whole lot of that anymore. But remembering that the positive cases do not have to be contracted at work in order to count. It's just if people at work in that place end up testing positive or getting sick. And then finally, what about the practical situation? Maybe you don't have a client who does this, but you have people working together. In this case, it's at a distribution center. They both drive forklifts. Roger calls HR Monday and says that he just started having symptoms this morning. He's getting a COVID-19 test today, and he says he wore his mask, but when he and Harold would pass each other in the aisles, they came within 6 feet of each other. And Roger says, I already called Harold this morning since we usually carpool, and I told him I think I got the Rona. What do? You're counseling them or you're counseling HR. And the answer to this is you need to investigate. You're going to need to look into it. The key here is the contact, what kind of contacts there were. This has not changed under the ETS. If you have been within 6 feet for 15 minutes or more within a 24-hour period, then that's going to be considered a close contact or an exposure. You may now, again, once the ETS goes into effect, need to determine if Roger is vaccinated. You may need to test Harold and others that maybe were in that 6/15/24 exposure. You want to document it, figure out who needs to be removed from work, if anyone, and when they're likely to return based on whatever the rules are at the moment, which is that right now it's a 10-day exclusion. Unless there's symptoms, and then you're going to work from the symptom date, and report to workers' comp carrier if that is required based on the number of people you've had so far. We want to answer the one question that's outstanding, which is there any size of the workforce to which everything applies? Most of this is going to apply to any size workforce. There might be certain things that are going to depend on the topic or question that are at hand. So sorry about that. I want to thank you all for participating in today's program with us. Hopefully it was a really quick overview of a number of issues, and you can see there's a whole lot out there. We can't in 1 hour possibly hit them all, especially when they changed the rules on us the day before. So thanks again, and hope to see you again soon, and make sure you get your MCLE credit. I think it will be emailed to you.